Hello, 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 everybody. Can everybody hear me? Because my thingy is not up on stream. Can you hear me, Nana? Put a 1 in the chat, Nana, if you can hear me. Okay, because it's not showing. Hang on, let me just... It's not... Are you guys seeing my avatar? Hang on a sec. Let me see what's going on here. Okay, you guys are seeing it, but I am not. Okay, let me exit and come back in. Okay, let me just exit, you guys, and I will come right back in. All right. Okay, there I am. Everything is working good. I can see everything now. Lena, hello, hello, hello. Nikki, Bobby, hello. Okay, so what we're going to do today, you guys, let me just get this up too so I have it up. There's been tons. I don't know what is going on with my computer lately, you guys, but I've been having a lot of problems with it. Let me just go over here to the Bryan Kohberger stuff. So I've got the latest. I know tons of stuff has been coming in. And I want to go over it with you. I specifically want to go over some IgG information that I have found. I was going to try this live stream with the restream because I want to get rid of StreamYards because they're just too expensive. But I had a bit of a time trying to set it up. I don't know how to work it, so I'm going to have to maybe use some of my members as guinea pigs and do some members only live and see if I can get it working and figure out how to work it. But anyway, enough of that. Let's just see here. Okay, so as we know, let me just share this with you. Let me share the window, this one, and share that way. I hope you can see my, yes, you can. Okay, let me make it big for you guys. Okay, so since November 7th, this was the last hearing. All of this, okay, so from the 13th down, so you can see 13th here, all of these have been filed, okay? Now, I do know that we went over some of these. The defendants had asked for this motion to leave, which means Ann Taylor wanted more time to go over documents and stuff like that. We also got from that, where is it? Right here. We have got the order denying, the judge denying the motion for leave. That was to give her more time. She's saying, I just got this, all the disclosure. Well, the disclosure was given to her on September 6th. And what the judge had said, he was not, we did go over this previously, but I'm just going to let you know that this is what happened with the motion for leave. Okay. The judge was a little upset and he said, before the court is defendant's naked, which means there's not enough information in it, what they need to go over, how much time they need, all kinds of stuff like that. That's what the naked, that's what the naked here means. Motion for leave. and it was filed on November 13th, in which he seeks relief from discovery motions deadline of November 14th, which means they had until November 14th to reply to these motions and the discovery that was filed by the prosecution. Now, like I said, the prosecution had filed that on September 6th, and they had more than enough time to put this motion for leave in if they didn't feel like they had enough time, right? But they waited until the night before to file this, and it was late at night. The defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in the case, and therefore he needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. The judge was not happy about it. The state's discovery deadline was September 6th. The defendant could have asserted far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention sooner, right? Further and importantly, defendant has not demonstrated with his filings good cause to enlarge the deadline, so the deadline is denied. So that's that. Okay, so then as soon as they filed that, they filed this Frank's motion. Let me just make it bigger for you. This Frank motion is 2 pages. Bryan C. Kohberger, by and through his attorneys of record, and moves the court to conduct a Frank's hearing. This motion is made pursuant to the Fourth Amendment. And basically what this is saying is they're using the IGG for almost everything. All of these motions that they filed all go back to the IGG. Now, what they are saying, okay, I'm going to just go over it because there's so many motions here. We will go over some of them, but basically what they're saying is because the IGG was used illegally, anything that they got from that IGG should be excluded, thrown out. So, which means any DNA final testing, the buccal swabs, any of the Google searches, all these searches. And I'm going to show you what they are right here. Like all of these, they are saying basically any of these search warrants and all of that and any data and evidence that they got should be excluded because it all goes back to the IGG. They're saying if they didn't have the IGG, which is against Bryan Kohberger's Fourth Amendment rights to this, I'll show you it here. Motion to suppress genetic information, which is the IGG testing. Comes now Bryan C. Kohberger through his attorneys of record and moves to suppress all evidence illegally gathered by law enforcement using genetic information. This motion is made in pursuant to the Fourth Amendment of the United States Constitution. A memorandum and exhibits are filed contemporaneously in support under seal. The motion is being filed under seal pursuant to Honorable Judge John Judge's previous order stating that pleadings related to this motion be filed under seal until the court could review the issues. Now, I know they took some of this to the Supreme Court, and I do believe that there was already a ruling on it. I don't really remember, but it's coming to me that there was already some kind of order or something made regarding this. We're going to see what I found, okay, regarding this. They're also saying that all the exhibits and everything will be filed no later than November 18th. Okay. So going back to this, she wants the motion to suppress the Amazon when they searched his Amazon, the warrant that they got for that, the warrant for his apartment, the warrant for Apple, the arrest warrant, saying that without the IGG, they would have nothing, right? So what the prosecution would have to show is even without, because they're saying that they weren't going to use the IGG information anyway in the trial. And how I understand this happened was it was the FBI that put the DNA from the sheath through CODIS. Nothing came back. What they did then was they sent the DNA that they had from the sheath to 23, I believe it was 23andMe. which you're going to see the FBI and law enforcement does quite frequently over the last few years. And what happened with that is when the FBI got back the information and the family tree that led them to Michael Kohberger, which is Bryan's father, that information said that the DNA on the knife sheath matched a male offspring of Michael Kohberger. That was from the 23andMe information. And we all know Michael Kohberger only has one son, which is Bryan, and he has 2 daughters. So the FBI calls up Moscow police and says, look, we got a tip for you. They're calling it a tip that you should be looking at Bryan Kohberger. Okay. So with that tip, okay, also came other tips. There was a tip that was also given by security from Washington State University, okay, that said, look, we got this guy that is in one of our lots. He rents an apartment here on campus. He has this Elantra you're looking for, and he's kind of weird, right? And that they had information that they seen his car coming and going the night of the red drums. So they had a tip from Washington State, the security there, and they had a tip now come in from the FBI saying that it's an offspring of Michael Kohberger. That gave them, both of those tips gave them enough cause to start looking into Bryan Kohberger. So what happened next? What they did was now they searched for Bryan Kohberger. They seen that Bryan Kohberger had been pulled over. So they had his address, they had his phone number, and they had what kind of car he drove, right? Just take a sip of my coffee here. So now they're gathering information on Bryan Kohberger. They also found out that Bryan Kohberger was getting ready to leave to drive back to Pennsylvania for the holidays. So he was followed, okay? They follow him back to Pennsylvania, and they start watching the Kohberger residence, okay? They start seeing Bryan Kohberger cleaning his car with bleach. They're doing surveillance on him, okay? They see him cleaning his car out with bleach. They see him taking garbage and putting it in the neighbor's garbage bins. So what do? When Bryan Kohberger goes back in the house, they go over the garbage bins and they grab it. In that was little plastic baggies that Bryan had been putting his personal garbage in. He was wearing gloves, and they seen all this. So they go to the garbage can, they get the DNA, they get the package out of there, they get DNA that matched Bryan Kohberger or Michael Kohberger, one of the two. So now they have their own evidence that showed, okay, we've got some kind of match here. I do believe that there was something in there that also had Bryan Kohberger's DNA on it. And they tested that and it came back a match. So then that's when they issued the warrant. Now, the defense is saying, no way, because the information that you got from the FBI was against Bryan's Fourth Amendment rights to, not have his information dissected like that without warrants and this and that and whatever. But as far as I'm concerned, I do think that it's legal. It is a tip that came in. It's not like Moscow went and did this themselves. They got a tip from the FBI that this is somebody you should be looking at. Okay. Also, they got the tip from the security at the Washington State University, the security guards there. So they had other people that also said, hey, you should be looking at Bryan Kohberger. They did look at Bryan Kohberger. Like I said, they had other evidence like his phone number and stuff like that. They started searching that, seeing that his phone was in the area, that his phone was turned off, that, all that kind of stuff, that they started getting GPS tracking and stuff like that, that looked really weird. So they issued a warrant. They felt they had more than enough probable cause to arrest him, and that's what they did. So, Jeannie, hello and welcome. But they are going to fight this. They are saying that they want that thrown out. They are saying that it was gotten illegally. So anything from that point forward should be gone. Get out. So here's the order denying the motion for leave. Now, there's an amended petition for an appointment of special assistant. Okay. Now, I do believe that before we get on to everything else, I'm just going to go over this briefly. This is just because now they have changed jurisdictions because we had the change of venue. The state refiled this saying that they wanted an okay from the judge and an amended petition for an appointment of special assistant attorneys general. This was already okayed when they were in Latah County, but now that they're in Ada County, they refiled it again. So they had the okay from this judge to also bring in attorneys general's office. And we have seen some of these people already, even when this was still in Latah County. Some of these attorneys generals that were mentioned were already working on the case. So this is just basically housekeeping type thing. Let's see what else is here. Stipulated motion, seal defendant's memo. This is a memorandum under decision and order on the death penalty motions. Let's see what this is. This is 55 pages. So this is the judge. They also filed a motion to have the death penalty taken off the table. The defendant is charged with 1 count of burglary and 4 counts of redrum in the first degree in connection with the deaths of 4 University of Idaho students. The state has filed notice of intent to seek the death penalty. Before the court are 12 motions filed by the defendant challenging various aspects of Idaho's capital punishment. We heard them argue some of this. I don't know why this isn't coming up. Oh my gosh, you guys, anyway, it's been denied. There's 55 pages here. But it was denied by the judge. So the death penalty is staying on the table. This is the order that the judge gave, allowing the prosecution to amend the orders appointing special assistant attorneys general, so they can do that. And then here, the defense is objecting to that order, telling the judge that it's not fair. Comes now Bryan C. Kohberger by and through his attorneys of record, objects to the amended petition for the appointment of special assistant attorney generals filed November 19th, and the request for decision without a hearing on the same. She's fighting this. This is 4 pages. She's saying that the plain language of the statute allows upon finding of good cause for an assistant attorney general to assist in the prosecution. They're not happy. They're not happy that they're going to be, hang on a sec. Yeah, I'll let you know. They're not happy that they're going to be able to bring other people in on this, okay? But, I mean, what's good for the goose is good for the gander. Ann Taylor has gotten all kinds of special witnesses, a GPS specialist, this specialist, that specialist, all these other different lawyers and everything that she's been able to bring in. So I think the judge is going to say, my ruling stands on this. State's response to the 19th. So they made another request for discovery. And I don't know why they're doing this, because there's the state's response to the defendant's 19th supplementary request for discovery and state's response to defendant's 6th motion to compel. they've got everything. Okay, that's basically what they are saying here. I don't know if this is going to load. That's what they're basically saying is they have everything that they were supposed to turn over and the dates that they've turned it over going right back to February 21st, 2023, that everything has been turned over. Discovery filed on September 4th. States respond to defendants 18th. So this was the state's deadline for filing their discovery, and they said that they have filed everything as of that date. And they did the same with this motion to compel. Here is the order on the Franks motion. This is only 3 pages. Order regarding the Franks motion. Before the court is the defendant's motion for a Franks hearing, November 14th, and a memorandum in support of a Franks hearing on November 18th. Accompanying the motion are 38 exhibits comprising over 2,000 pages. So this Frank's hearing, all the sealed stuff that she filed is over 38 exhibits and 2,000 pages. Okay? And this is like, what the hell are you doing at this time of the game? Filing over 2,000 pages for a motion? It's ridiculous. What she's trying to do is bury the prosecution in paperwork, okay? What she should be doing, in my opinion, is going over all the discovery that she's complaining she doesn't have time to go over, and her people don't have time to go over this. Well, you don't have time because you're filing crap like this. 2,000 pages of motions material and 38 exhibits. The judges had enough, okay? Unfortunately, the defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. She wants this judge to sit there and go over 2,000 pages and give some kind of order for in her favor. Like, no judge is going to do that, okay? Thus, the court is left with the inevitable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. And we've seen this, you guys, when she filed that 400-page motion. Well, now she's got over 2,000. But we've seen this before with a 400-page motion. And it's like, stop arguing the law or rights as you want them to read. Instead, let's go by what they are instead of what you want them to be or what you understand them to be. Let's go by what they are and what has been used for decades. Stop trying to go back to 1800s law and change the law. I've said this so many times, you guys. And a lot of this, I can just see it now is going back again into 1800s and stuff like that, right? The judge is pissed. Thus, the court, okay, we just read that. The court is not required to search the record looking for evidence. Consequently, if the defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony for the facts asserted. In addition, defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion. Like, stop this. Stop bringing up laws and want them to read the way you want them to read instead of the way that they read. You know what I mean? Like, stop it. Because the state is under a deadline to respond, the court will allow the defendant until Tuesday, November 26th. So she has until tomorrow to resubmit 2,000 pages worth. Like, this is getting ridiculous. If she doesn't submit it before November 26th, he ain't going to hear it. And it's going to be squashed, gone. So that's where we're at with this, you guys. Like I said, all these things that she is um, saying that should be thrown out because of the IgG testing. It all goes back to the IgG testing. They're saying they got his initial DNA, well, actually his father's, that showed that it was an offspring of his father, Michael, that they got that illegally and against their constitutional rights. So what did I do? Let's get rid of this. What I did is I went through and found this. Now I'm going to read it. I know it's small on the screen, you guys. Um, and this is what I found regarding the IgG. The lack of legal precedent on the subject is one of the many reasons why the University of Idaho murder case is drawing so much attention, not just from the unusual true crime reporters, but also legal reporters and scholars. While the judge has yet to set a date for the trial, which he has at the time of this writing, he hadn't yet, but now it is set. It is likely the issue of the genetic genealogy will come up before, during, and possibly even after the trial. The few existing state and federal laws that we currently have are not enough when it comes to the regulation of genetic genealogy and its use in criminal investigation. Neither the current laws nor past court rulings involving traditional DNA searches or reasonable expectations of privacy that were established prior to the advent of genetic genealogy technology are adequate to solve the challenges and the questions that this new technology presents. Answers to questions, or even attempts to find answers to questions like who exactly owns and controls our DNA, arguably our most personal of all property. Give me 2 seconds, you guys. Okay, sorry about that, you guys. I had to get it because that was from the hospital. I got to go in and get this monitor put on for a week. Anyway, let's get back. Um, Answers to questions, or even attempts to find answers to questions like who exactly owns and controls our DNA, arguably our most personal of all property that we possess, but are constantly shedding and leaving behind wherever we go, and parts of which we share with others through no choice of our own, are not going to be easy tasks. However, we cannot wait for the courts and the states to slowly assemble a patchwork of laws. Instead, what is needed is both state and federal legislation that will protect Fourth Amendment rights, even in a time where DNA, which was once locked in mystery, is increasingly becoming public information, regardless of whether we provide consent or not. So I know there was parts of this right here. As of this writing, which was just a few months ago, there is no national standard for the use of genetic genealogy. 12 states allow for the use of it, while Montana and Maryland are the only two states that have explicit statutory limitations on the use of the genetic genealogy and familial searches. So right now, 12 states are allowing it. So I do think that the defense is going to have a hard time getting rid of the IgG stuff. Um, the lack of precedent, you know what I mean? and stuff like that. And being that 12 states allow it, I think is going to weigh heavy on the judge. Let's see. So here, Lynch's statements about this being used for minor crimes are backed up by the data. In October 2019, it was announced that out of the 10 requests made by law enforcement to access 23andMe database, the majority of the requests concerned credit card fraud. There's a tendency for judges, for the public to say, oh, well, these crimes are so terrible that it justifies any kind of search to possibly identify the person. But what we have to realize is that these kinds of investigative techniques are not limited to cold cases and not limited to heinous felonies. They will be used in even minor crimes. So what she is saying is, like, they understand if it's limited to cold cases and not limited to heinous felonies. So it seems to me that there's a lot of people that I'm going to link this in the description if you guys want to read through it all. This goes through what, people think of it, and, just how it's been used, and judges have allowed it. Let me just see, even a so here it says, even a 2018 interim policy issued by the Justice Department on the use of familial genealogical genetics, oh my God, FGG, by federal agency that states investigative shall identify themselves as law enforcement to services and enter and search FGG profiles only in those genealogical genetic services that provide explicit notice to their service users. So, I mean, see here, in the summer of 2023, it was revealed that California's Riverside County Regional Cold Case Team uploaded a victim's DNA to the commercial site MyHeritage, despite the fact that doing so is a direct violation of the company's terms of service. It was further claimed that Riverside County Regional Cold Case Team may have acted with cooperations from FBI. Lastly, there is also the question of those individuals and companies that are comfortable with DNA data being used for investigative purposes in cases involving serious offenses like murder or SA, but object to it being used in lesser crimes. So, I mean, I think that they are going to lose their fight because I feel like a lot of states are allowing it. So I do feel like the judge is going to say, like, it's not going to be thrown out. The Fourth Amendment protects against unwanted searches and seizures and is seen as the major source of privacy law in the United States. While some originally interpreted it mostly as an effort to protect places, the Supreme Court shifted Fourth Amendment doctrine from a property tort-based approach in Boyd versus the United States to a reasonable expectation analyst in the famous wiretapping case with Katz versus United States. In Katz, Justice Harlan defined a new standard for judging reasonable search and seizure. There is a twofold requirement. First, that a person have exhibited an actual subjective expectation of privacy, and second, that the expectation be one that society is prepared to recognize as reasonable. But they're saying that when they put their DNA into a database, they should understand that it's not going to be private anymore. You're giving companies your DNA to use, for their services and possibly other things. So the issue of what is reasonable is still a question of debate and is even more of a challenge in situations involving the use of genetic genealogy to apprehend suspects. The state successfully argued under California versus Greenwood that the Fourth Amendment does not require a warrant to search DNA found on items that a suspect has discarded because the suspect abandoned their privacy interests in their DNA when they left it behind on those items, right? So that means even searching that garbage. So it also says here, although Greenwood may not seem applicable in cases involving the use of genetic genealogy, an argument could be made that when one decides to upload their DNA profile on a publicly shared database, they lose their right to DNA privacy. So it must be noted that in the vast majority of these recent cases, including the Golden State Killer, and it was allowed there too, right? And the University of Idaho Redrum, the suspects did not actually upload their DNA themselves. Rather, relatives, many of whom probably were not even aware of the existence of said suspects, were the ones who did that. Likewise, the third-party doctrine ruled that under the Fourth Amendment, an individual loses reasonable expectation of when they volunteer information to a third party, and would not appear to apply to those sorts of suspects either, since it was quite hard to argue that anyone volunteers their DNA to a third party by virtue of being related to them. So, I mean, I do think that they are going to lose their fight. So I will link this in the description after we're done the live, but I've also found this too. You're not feeling well today. Oh, I hope you feel better, okay, Mitch? I'm praying for you, girl. Okay, so this I came across. This is from Criminal Law, Investigative Genealogy, Forensic Genealogy, and DNA. This is from the Texas. Willow can't talk today. The Texas District County Attorneys Association. That's what this is from. So Investigative Genetic Genealogy, IGG. I'm just going to call it IGG. A guide for prosecutors, okay? Forensic Investigative IGG, also abbreviated as FIGG, IGG, or FGG, is a groundbreaking tool in the field of criminal investigations. It is, I can't speak today, revolutionizing the way DNA evidence is utilized while giving law enforcement the confidence to solve previously unsolvable violent crimes. Reflecting this confidence and enthusiasm, one investigator remarked, I truly believe that this is the new fingerprint. It has resulted in identifying suspects in tricky cases that would not be solved any other way. A seasoned genetic genealogist explained, in case after case, the comment is that person was never on our radar. While IGG represents a game-changing advancement for law enforcement, it must be employed with reasonability and ethical consideration. Legal and privacy concerns should always be paramount. When used ethically, IGG stands as the most effective investigative method in modern criminal investigations. So they go into say what IGG is, and this article will give an introductory overview of how IGG is used in criminal investigations and prosecutions. So they have the County Attorneys Association has a whole thing on this where they tell the prosecution how they can use it. So I will also put this in the description below if you guys do want to read through all this. Let me just see. Okay, so the Department of Justice Interim Policy for Forensic Genetic Genealogy. So they have an interim policy on how and when you can use the IGG. So before proceeding with the type of forensic testing required for IGG, also known as SNP, SNP testing, I should stress that law enforcement should follow the Department of Justice interim policy for forensic genetic genealogy, IGG, DNA analysis and searching. It is critical for all agencies involved in IGG investigation and prosecution to communicate with each other to ensure they are not risking federal grant funds by violating the policy. As federal law enforcement agencies and those receiving federal funding for IGG must follow the policy. Plus, its protections and procedures are in place to balance the interests and privacy rights of the public. The Policy is clear that IGG is an investigative lead technique that should be used for identifying suspects only in violent crimes. And they include red drum, attempted red drum, and SA, as well as for identifying unknown human remains. So there is a policy in effect on how law enforcement can use IGG. Now, it's not, it hasn't gone through all these things that usually policies will go through, but it is a policy that is in place, that the only time that they can use it is for identifying suspects only in violent crime, such as red drum, attempted red drum, and SAs, as well as for identifying unknown human remains. The policy requires law enforcement to get prosecutor concurrence before using IGG. There is an exception to the violent crime requirement when it concerns a matter of national security or there is an ongoing threat to public safeties. Okay? So, using this IGG to investigate to see if Bryan Kohberger, was in the area and this and that of this crime was because of the threat to public safety, right? So I will link this also because it goes through, it's a lot of pages and I'm not going to read through it, but I do believe that they're going to be able to use the tip from the FBI. And this too is interesting. IGG at trial. At trial, nothing changes. The prosecutor should not present IGG investigative evidence at trial, which means how they got to Michael Kohberger. They can't show the family tree and all that stuff. The evidence prosecution will use to identify the defendant will be the buccal swab, STR, DNA confirmation testing that was taken subject to a search warrant or at the consent of the time of the defendant's arrest. So that is why the prosecution has said they're not bringing in the IGG, because it is here that they cannot do it. They're following what has been set out so far for the preliminary use of IGG, and this is the rules for the preliminary use of IGG testing. Okay, so like I said, I will also link this whole thing in the description of the video. So I do think, I'm hoping that somebody either on the prosecution or the judge himself is going to know about this policy being in effect, right? So what do you guys think? What do you guys think that they should be able to use the IGG with what I just showed you? Do you think that the judge is going to deny the motion to have the IGG, which means all of the evidence that they collected since using the IGG tossed out? Anything that they got because of that IGG, she wants thrown out, which is basically all their evidence. What do you think the judge is going to do, you guys? Let me know what you guys think. What do you guys think? So the rules and everything for using IGG is here. And it is from Texas County Attorneys Association. And this here is criminal law and investigative genetic genealogy, forensic genealogy, and it's a guide for prosecutors on how to go about using IGG. What do you guys think? I hope that the prosecution has this. I hope. I don't know if they do, but I hope they do. I'd like to send it to them. I would. Somebody should send it to them. Hope the judge doesn't throw any other. I don't think he's going to. I think he's going to allow the IGG, especially if they have this, which is the guide for prosecutors in using the IGG and the interim policy for using the Department of Justice interim policy for using the IGG. And this is a guide for prosecutors on how they can use it. And this is why the prosecution said that they wouldn't be bringing the IGG into it because they're not allowed to. So they're following this. So I'm hoping that they do have this. But I don't know. Like, can you guys send stuff to the prosecutor's office? Are you allowed to do that? Because I think this should be sent to the prosecution's office just to make sure that they have it. What do you guys think? I'm not in the States, so. Okay, Mitch, are you still here? Hey, Mitch, are you here? Okay, so here is the link. I'm going to put it in the chat. I don't know if you guys are able or allowed to send stuff to the prosecution, but I think that this should be sent to them. This is, like I said, I'll share it one more time here. This is the IGG, a guide for prosecutors. And this is the County Attorneys Association on them, the Department of Justice preliminary interim policy and how prosecutors, that's what this whole article is how prosecutors can use it. So I don't know if somebody there can send it to the prosecution. But that's the link to it right there. Although I would think if you found it, the prosecution probably has it. I don't know. Don't forget, the prosecution right now is being buried in paperwork with 2,000 pages of motions. You know what I mean? I mean, it wouldn't hurt. I just don't know if you guys, if the states allows that, if you could send stuff like this to the prosecution. What's BS? What's BS? What's BS, K Mitch? I'm waiting for K Mitch. Yeah, I know what BS means, but why are you saying BS? Okay, while I'm waiting for that, I got to put this on my calendar because I'm not sure what you're saying BS to, though. What do you mean? I think it goes by each state laws. Well, hang on. Let me just look at something. Whoops. Let me look over here. Whoops. Okay, hang on. I gotta stop sharing. Hang on a second. Well, this was in California. The Golden State Killer was in California, and they used it, and they talk about it in here. So I think this is across the US because the Golden State Killer, that was in California. See? And they used it here. Even after 5 years, it's impossible to discuss IgG without mentioning the Golden State person, a prolific serial, you know what, in California. So the Golden State was in California, and they used this. This is still mentioning that. So and they did say that it was used across 12 states that allowed it, except for two, Montana and something else. It wasn't Idaho, though. See, this whole high-profile case was solved using IgG. So it was allowed in California, too. The GSK case was a spark that ignited a transformational investigative phenomenon that is just starting to catch the surface of its full potential. Since the Golden State arrest in 2018, IgG has helped clear over 1,000 cases, many of which involve serial offenders. So this has been used over 1,000 times. And this is just the ones that were that appeared in the researchers' search results. The actual number of cases cleared using IgG is likely larger. Let's just see. I'm too sick to keep up. That's okay. That's okay, K-Much. See, here's another case here. By 2017, investigators had exhausted traditional methods for tracking. Oh, that's the Golden State. Okay. But I believe the Department of Justice is across the whole United States, isn't it? The Department of Justice? The Department of Justice rules every state, I think, not just one. The Department of Justice, it's not Texas's interim policy, it's the DOJ's interim policy. So I would assume that the DOJ runs right across all states. And they're saying that the policy is clear that IgG is an investigative lead technique that should be used only for identifying suspects only in violent crimes, which include red drum, attempted red drum, and SAs, as well as unknown human remains. So I don't know, you guys. I'm gonna put it in the description so you guys can read through it all if at your leisure. But I do believe that they are going to be able to use it. So with that being said, you guys, I'm going to wrap it all up. I'm not going to take too much more of your time. Wrap it up and let you guys get back to doing what you were doing. But I want to thank you guys for being here and for watching. Thank you for the mods being here. Kay Mitch, I'm going to say big, big, big prayers for you. I hope you feel better soon. And you're well. I hope I can't talk today. You recover quickly. So until then, you guys, please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Take care. Bye-bye.